Ms. Julian Ferris appears on behalf of the plaintiff. Mr. Rice is in pro se. Is there anything in front of the court regarding this file?
Your Honor, as it relates to the child support show cause that the friend of the court had filed, we would ask that that be set aside. Mr. Rice has submitted the required documentation to our office.
When was it due though?
The order had entered on January 9th of 2024. We began the review process after the order entered. My understanding is that there's non-traditional sources of income with required tax information, and tax returns hadn't been filed until recently. So that information has now been filed.
I see, but last year's.
3 years.
Oh, that's right. You need the 3 years. Okay.
Yes.
All right. Ms. Ferris, do you have any comment?
No, Your Honor.
Okay. All right. Well, you want to proceed with your motion?
Yes, Your Honor. I do have a proposed order if I may approach.
Sure.
Good morning, Julian Ferris on behalf of the petitioner, Christy Bieber. An order regarding custody, parenting time, and support was entered by this court on October 5th, 2023. That order was based on a friend of the court recommendation that was completed several years earlier, but an order was never entered at that time pursuant to the recommendation. The recommendation and the order both state the party shall follow 2016 parenting time guidelines and are silent as to everything else: transportation, appropriate communication, talk time with the minor children, etc. So we're not asking to change custody, parenting time, or support. We are just asking that the standard clauses regarding communication, transportation, and general child welfare are added to the order. So we are asking that both parties be ordered to follow the reasonable recommendations of professionals treating the minor children, including doctors and counselors, and that they both give the children prescription medications as prescribed. We are asking that both parties be ordered to take such reasonable and necessary steps to ensure that the children are ready to be promptly transported at the designated time, and to return all of the children's clothes, homework, schoolwork, medications, and other personal effects delivered to each party by the other party when the children are exchanged for visitation purposes. We are asking that the parties be allowed reasonable telephone access, text message, video calls, or electronic messaging with the minor children when the children are in the custody of the other parent, and that if the parties can't agree, we would ask that reasonable telephone access take place on Tuesdays and Thursdays at 7 p.m., and that the children be entitled to private telephone conversations with parties and not be required to have their conversations monitored or on speakerphone. We are requesting that any communication between the parties be limited to matters that are for the benefit of the minor children, and that the parties utilize the AppClose co-parenting application for the purposes of all non-emergency communication, including the use of the calendar function. And we are also asking that both parties be ordered not to speak negatively or in a degrading manner about the other party or his or her family or household members in the presence of the minor children, and to prevent his or her family or household members from speaking negatively or in a degrading manner about the other party in front of the children as well. And this provision should apply, but not be limited to verbal comments, text messages, and social media posts. We are asking the parties not discuss adult topics, including court proceedings, with or in the presence of the minor children. And lastly, we are asking that the parties be ordered not to leave the minor children alone with, babysat by, in bed with, or transported by adults that are unknown to the children, unless previously agreed to in writing by the parties. Upon information and belief, my client is worried that the defendant does not have his own housing, that the children do not have their own space or their own beds. It's believed that the defendant is living with renters or workers and letting his kids sleep in bed with them. And because of this, we are asking the court order that the defendant obtain and maintain appropriate housing with beds for the children, so that they're not sleeping in the living room or in bed with a stranger.
Very well, thank you. Mr. Rice?
Basically, it only happened one time, and actually my daughter requested to sleep on a bed, so it was only a one-time deal. The person that they're talking about is actually being kicked out at present time. I have two houses. I kept the house in Kindy for the kids, so I have the proper housing.
So do you have any objection to what's being requested then?
No.
So order, present an order to that effect, which we have right in front of us. Or we'll execute the order at this time.
There's also a show cause for my parents.
Let's proceed on that.
Go ahead. We received a complaint from Mr. Rice that he was allegedly denied his parenting time for the weekend of February 16th, 2024. That was submitted to the court for show cause along with a police report from FedEx PD regarding that weekend. That is the show cause.
All right. So, Mr. Rice, you claim you were denied parenting time for a weekend,
Yes.
and what are the circumstances? What was going on?
Basically, she was worried about the people that are around, and there was no, like, she had no evidence. And my daughter actually requested to sleep
Well,
on
we
the
can't
bed.
go with what your daughter may have said, but go ahead.
That's all it was based on. So it was all hearsay. And that's what they're holding the kids back for.
Ms. Ferris, do you have a response?
It was that one weekend. It was because my client was worried. Because as the defendant mentioned, he did let his daughter sleep in bed with a stranger the one time. That did make her nervous. She came and spoke with me. There have been no further denied parenting times. And there, as the defendant said, been no other incidences of the kids being left alone or sleeping with strangers.
Okay, thank you. The person that, I don't need to know a name, Mr. Rice, but the person that you were referring to that was being kicked out, is that the person in question?
Yes.
Okay. I find the show cause, I'm dismissing the show cause. There's proper cause. I don't like individuals taking the law into their own hands. But under the circumstances and hearing Mr. Rice state as well, that he is removing this individual, that indicates to the court that it was a problem. And as a result of that, I'm going to dismiss the show cause.
Thank you.
But don't take the law in your own hands. Mr. Rice?
She requested it and she was actually next to her daughter. So there was no, she actually requested it. So there's no, like, she didn't feel uncomfortable or anything else. I would never had her even close to her, and she actually wasn't close to her.
I understand, but I made my findings in this case, and now we have a clean slate. Let's start brand new. These children are very important to both of you. Let's go in a positive fashion. The plaintiff's motion regarding her taxes and address update. Parties are present in this case. Would you both please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes. The court reviewed the motion in this case, Ms. Swatwood. It indicates that Mr. Heilig filed for income taxes on both of your child for 22 and 23. And the judgment that was entered in this case indicates that you shall have claimed the minor child for any and all tax purposes, benefits, or credits, including local, state, and federal. Defendant shall cooperate in executing and or providing any requested documents to achieve that within 7 days of the request. That's your issue, correct?
Yes, Your Honor.
Okay, and you were not able to claim the child.
No, I was not. I have a denial of my taxes here. If you would
Saw
like to. Oh,
Yep, I
okay.
saw it. It's contained within this file.
Okay, yeah, so
You're fine. What happened, sir?
A mistake was made and I did receive the tax credit for our son Jackson. On Friday, I have filed an amended tax return. I have proof of filing the amended tax return, and I'm just waiting for the papers in the mail so I can start paying it back.
Okay, what about 22?
As of 2022, we had a verbal agreement that I was going to file for him, and I have proof of her in text message form confirming that we had an agreement to file for, that I was supposed to file for him on 2022 taxes.
understand a verbal agreement is not worth the paper it's written on.
Okay.
But you said you have some sort of documentation in the form of text message?
Yes, of her admitting that she did not inform her mother of the agreement we had had.
Do you remember anything like that, Miss?
Your Honor, it was talked about, but then I did say that I was going to be claiming the check because my mother does my taxes and she wasn't going to allow me to let him claim Jackson because I have him. I have him all the time. He only has him 4 overnights out of a month.
Okay,
And I
so
postal and legal, so.
are you asking for 22 as well?
No, just
Oh, just
23.
23.
Just 23.
Okay, okay. All right,
And then the child support as well, is inconsistent. I only get child support around tax season. I have all of our child support records since our case has been opened. If you'd like to look at that, I only get.
well, I can get that from the front
Okay.
as well.
Oh.
Mr. Holbrook, is there sporadic payments of support in this file?
And Your Honor,
Yes, payments are inconsistent, Your Honor.
Okay, go ahead.
Your Honor, when I have asked Mr. Heilig about payments, he has accused me of harassing him. So I now just go to the front of the court because I'm not trying to, he'll promise a payment, I'm like, hey, I'm gonna make a payment, and then I kind of count on it, and then it never comes through, and then I quote unquote harassing him when I ask, hey, you said it was gonna be here on this date, and it's not. So I would like to also request that, I know there's a court app that we can use to talk through, just so that everything is on record.
App close.
Yeah.
That's what it's called. Do you have any problem with app close, sir?
No, I would much appreciate
I'm
that.
going to order that as well.
Can that be in our order that that's the only form of communication?
Yes, that'll be the only form of communication other than emergency. If there's an emergency, God forbid a child is injured, obviously that's a different story. So app close will be the exclusive there regarding communication. But so I just want to be clear though, with 23, you should be receiving documentation here, and then that will allow you to file your taxes claiming the child.
I'm not sure.
It should, but
Your Honor, the amended tax return has already been accepted. As far as I believe, she could probably file her tax return today.
okay, well, we can see if what we will do then is if you do wish to refile here rather quickly and you're denied again, renotice this and we'll bring it back.
Yeah.
But I'm going to grant the relief to you.
Okay.
Okay, and because the court order is very clear, the judgment, which indicates that you are to claim the child, period. So that will be granted. What is this about father's address?
His mother owns a house in Memphis, which is 3 hours away. He lives in Memphis, and to my understanding, which he has told me, he lives in a duplex, a second story duplex, with his girlfriend and his daughter. And my son has expressed that to me as well.
You can't go to what your son.
Well, Mr. Highland has expressed that to me. The address that he has given is his mother's address, and I have a pull-up and screenshot, and her name is listed on the property. His sister is living there right now because his mother lives with his boyfriend, and I know his sister is living there right now, but he is not living there, and that's what he's telling me. I would like to know where my son's at and where he's going, where he's staying. That's in our court order that our addresses are supposed to be listed. He has my address listed.
Response, sir.
My address has not changed. I live at 8 Michigan. I live in the house with my sister. My girlfriend does own an apartment. It's not a duplex, it's an upstairs apartment. And I stay with her a couple nights a week, especially when I have my son, because with me and my girlfriend, our daughter together, and my son, we have the family together. My sister brings her boyfriend over. It's kind of a privacy thing between us that we get weekends apart from each other, but I still do live in that house.
Your Honor, I'm only supposed to know his address so I know where my son's staying. So if he's taking my son over to a different location, the only purpose of me to know his address is to know where my son is staying when he has him. He has no physical or sole custody of him. That's the only purpose for me to know his address. So I would like to know where my son's staying, regardless if that's what he has on his ID. Every time I talk to my son, when my son is at his father's, he is at his girlfriend's house. He's never, and my son complains that he can't sleep there because he shares a room with his baby sister.
I've got it. You do have sole legal, sole physical.
I do, Your Honor.
And so, Mr. Hiley, we are going to need the other address as well.
Okay.
You can submit that to friend of the court. You can share that with.
Again, it's not my address, Your Honor. This
No,
is where my girlfriend lives.
No, I know that.
Okay.
I understand that completely. The only reason I'm saying that is in the event you have the child, because you don't even have legal custody. If that child is injured, you need to go somewhere, or mom needs to get involved to provide authority for medical service, she needs to know where the child is. So I'm going to ask you to provide that address, not on the record right now,
Okay.
but when you walk out today, provide the address to mother here, and that should take care of it.
Okay.
Sound fair?
Yes, Your Honor.
Any questions either?
No question.
Have we covered everything?
Will there be some sort of paperwork that I
There'll
can
be an
send
order,
out
there'll
for
be
my
an order
taxes?
prepared. Oh, no, I'm sorry. The court will have an order regarding our decision in this case. Regarding the taxes, I can't render legal advice. All I can tell you is I would, if it were me, I'd just be filing my taxes again to see if the child can be claimed.
Okay,
And again, if the child cannot be claimed, renotice this matter and we'll bring it back before the court.
okay, thank you.
Any questions again?
No question.
We're good? All set. Thank you.
Your Honor, on February 5th of this year, we received a complaint from Ms. Myers regarding Mr. Myers being with minor children around his parents and falling asleep, not providing supervision of the children. This was filed when there was an order entered on September 6, 2023, stating that the minor children were not to have any unsupervised visitation with Mr. Myers' parents. And the allegation is allowing the children to have contact with his parents without direct supervision from himself. This matter was originally scheduled for February 22nd, which was the divorce trial date for the parties. At that hearing, I do believe Mr. Myers had counsel. They had reached an agreement on everything. This notice was sent to the last attorney that we had been speaking with on behalf of Mr. Myers. But I believe his attorney that was representing that day had no knowledge of it, so the court had adjourned it to today.
And I see that Ms. Sunblad has submitted to the court a notice of termination of limited scope representation.
Correct.
So we can proceed.
So we can proceed, yes.
Okay. Ms. Myers, obviously I heard from Mr. Holdridge what is the issue, what the issue is, but what is going on? What do you have specifically firsthand knowledge of this?
That this is not the first time he has left the kids unsupervised with his parents. It's been 4 times since we have initially agreed with front of the court that they were not supposed to be unsupervised with his parents. The first time it wasn't court ordered yet, so that was not brought to attention that we couldn't do nothing about it. Second time, we were in on December 1st, he got a fine for $100 for leaving him unsupervised. Third time, front of the courts, I don't know what they were saying. It was December 30th, he left them at his sister's house for a family Christmas, knowing his parents were going to show up. And then he decided to leave without taking the children with him. And when he got back, the children were there with his parents, unsupervised by him again. That was brought up, but I don't know, front of the court said something about the court order was changing, which at that point in time, there was still a court order that they were not supposed to be unsupervised. And then February 4th, he took the kids over to his parents again, and all 3 children stated that he fell asleep on the couch. They tried to wake him and he would not.
All right. And how old are the children?
8, 5, and 3.
Mr. Holbrook, do you have any comment relative to what Ms. Myers was stating about what the friend of the court did something or didn't do something?
We had received a complaint before, Your Honor, and the show cause was scheduled when the investigation was going on. And no, that hearing was held. Mr. Myers was found in contempt. He did get a fine. There was another complaint that came through while the report was being conducted and was taken into consideration with that report and then was set for trial. on that day. The parties had reached an agreement on that. After the report was issued, this complaint came through and the show cause was
I see.
addressed.
Okay.
Because originally with the recommendation.
But you
was-
said the show cause was addressed?
No, this show cause was filed after the,
Right.
her other complaint that you mentioned was addressed in the report. But that portion of the recommendation was not adopted by the parties in council when they had that agreement. The parties had agreed that that provision remained, that direct supervision by plaintiff or defendant continued. Yes, our recommendation was slightly different, but still regarding supervision.
So it's still there.
That's still in there now because with the divorce.
Got it. Okay. Mr. Myers?
For the February 4th, I was wide awake on the couch. We sang happy birthday to my daughter. We celebrated her birthday that day. We had ice cream cake. We did everything. I don't know why these allegations keep on coming up, but I made the mistake first time, learned from it, and I haven't left my kids alone with my parents since. And my parents also agreed that they will not be alone with them without me there. So, like I said, I was not sleeping on the couch. I was wide awake. We sang happy birthday and enjoyed cake and ice cream and everything.
Okay. So if that's the case, I'm assuming neither party would have a problem with the court speaking with the 8-year-old.
I'm fine with that.
That's fine.
Okay, let's do that. Let's do that. What are the parents' thoughts of the 5-year-old?
I'm fine with that too.
That's fine.
Court will take the matter under advisement, have the opportunity to speak with the children in chambers with friend of the court. And the whole point beside of doing this, folks, is I don't like to place children on a witness stand.
Yep.
Facing mom and dad. That's the only reason. So I think it's the best way. And I don't want to traumatize them. It's a lot easier back in chambers, and the court will receive whatever information it can receive, and then we'll reconvene in.
The child on Thursday, April 4th, and then we can convene April 5th.
Is that a possibility, meeting with the children April 4?
Just checking the schedule.
No, that's fine.
Just to make sure.
And you raised your hand, sir.
It just seems like every time my children go back to their moms, an allegation is made, whether CPS shows up to my house or sitting back in here. And I don't know why or what's going on with why the kids want to make allegations all the time like this, but it seems to be a normal thing. I've had CPS at my house 3 times. We've been in here once. This is the second time being in here. It just seems like.
I can't speak for that. All I know is that there was a motion filed and I have to address it. You raised your hand.
Yes, I would just like to address to what he stated is it's entirely solely because the children are not happy or wanting this, what we are doing. They don't want to be with their dad, and they have stated it not to me, to him, to many other people,
Well, hold on.
because of the issues he's doing with them.
Time out. The issue here is allegations of father violating the court. If parents are fit, the court's belief is that the children should have opportunity to be with both parents. And we're talking about an 8-year-old, a 5-year-old, and 3-year-old. Let's just focus on what's most important here now, these allegations, because these individuals, no disrespect, are off limits if dad's not in the room, right? So that's what I want to find out. So let's address it that way. Regarding calls to CPS and the department, I have no control over it. All I do know is what's before the court. We'll address this issue first. Can we do April 4 and 5 then?
Yes.
Does that work?
Your Honor, I would just ask the court to instruct the parties that they're not to have any conversations with the children about this upcoming meeting.
Good point.
Yep.
In no way, shape, or form.
Or at 3:34 o'clock.
Would 3:34 o'clock work?
Yeah, that's Thursday.
They get picked up at 3:10. As long as the roads are fine, I can have them here by 3:34 o'clock. Yes.
Well, we just make it 3:45.
Sounds good to me. I'll have them
I'm
here.
gonna give them.
We'll give you a notice as well, Ms. Hatch will, for the next year.
All right.
That's how we'll address it. Any questions?
No, sir.
All right. If you just want to stand by for a moment, that'll be printed out. We'll be free to go. Thank you.
Thank you, sir.
Off the record.
Nothing but the truth, so help you God.
Yes.
Thank you. All right, we met with the children yesterday. You're very proud, wonderful children. Very articulate, very bright young individuals. Not mentioning their names, but I was very impressed, to say the least. Mr. Holder, do you have anything to add?
No, Your Honor, I would agree. I had the opportunity to speak to them during the investigation, so this is my second time getting to see them, so I would agree with that statement. This issue was brought before the court for a show cause during the divorce trial in February, at which time Mr. Myers' attorney stated he did not receive a copy of it. So that issue was adjourned to March 22nd, came back for the children, which was yesterday. And we're here today to finish up the show cause with the alleged violation that Mr. Myers had the children around his parents without direct supervision himself.
Thank you.
And I believe this would be second and subsequent violation.
It would. Okay. Ms. Myers, do you have anything to add?
No.
Sir, do you have anything to add? Well, this is what the court has gathered. Again, I'm not going to, because I make it a policy and an absolute promise to all children that I interview to avoid having to put them on a witness stand to get their side and get their impressions and get their feelings. It appears to this court that both children adore both mom and dad, have good relationships with both mom and dad, and for the most part, everything seems to be going very, very well. Issue, though, is the no contact provision regarding Mr. Myers' parents. And the court, again, had the opportunity to meet with the children to discuss this. I'm not going to go into what the children said. However, something needs to change here. Father, you work third shift, correct?
Correct.
The issue is not only that, and again, we don't fault parents for working third shift. That's not a problem here. But someone needs to have time to sleep as well. On the flip side, the children need not be inundated with adult matters. You know where I'm going with this. It doesn't help. It doesn't make a good situation. And with young and impressionable minds, that can lead to problems down the road. Now, it's one thing to try and pump information, but on the flip side, there's also legitimate concern. No question, there's a legitimate concern because, if I'm not mistaken, the individual in question has a conviction for criminal civil conduct 3rd degree and 2 criminal civil conducts 4th degree involving minor children. And maybe I'm overprotective, but that's a red flag. So prior to all of this, prior to the divorce judgment being entered, the court was aware that this was an issue, 1. And number 2, the front of the court had contemplated an idea to resolve it to where we're not putting the children in the middle or pumping the children with information or asking the children information about the other parent. Because that's a dangerous slope to go down. What I am proposing to resolve this matter is simply this. What was recommended by the friend of the court. That is, when father is around the individual in question, the 2 individuals, that it's either father as well as or another adult individual that both parties can agree on can be watching in the event dad falls asleep. Dad steps outside to do something and comes back in. I'm throwing it out there because the only other way that this can be addressed is either one, the children are completely off limits to this individual regardless of who's there. Well, that's the only option, really. That's the only option other than having a third party that both parties can trust and accept. Mr. Holbrook?
I'm sorry, Your Honor, I just was reviewing that order here and I see it's slipped in there on the last sentence of this provision.
Okay.
That the children not be left unattended in the presence except when supervised by the parties. And it does state with third person approved by the parties with the children, while the children are in their care, except when the accepted supervisor is going to that. So that was put in there.
Oh, it is in the order.
Yes, it's my recollection when this was put on the record, that was not, because that is what I had recommended in my recommendation. But when it was put on the record with the attorney, that wasn't there, so.
But the written order reflects that.
Correct, the written order does reflect that, looking at that right now,
Okay.
that there is a third person approved by the parties, yes.
Okay. So, well, I guess we do have it in place then. Is there someone that can be that third party? Dan, go ahead.
My girlfriend, we tend to do everything together. But she has always been there with the kids also. Every time I go to my parents, I take her kids, my kids, we all go all together. So that is one person I would recommend.
So your girlfriend's own children go there?
Yes.
How old are those children?
Oh, my kids are 3, 5, and 8. So 4, 6, and 9, I would say. Might be off by a year.
Somewhere in there.
Yeah.
Okay.
Because between all 6 kids, it legitimately goes 3, 4, 5, 6, 7, 8, 9.
What is your significant other's name?
Rebecca.
All right, Ms. Myers.
We did not agree to her, watching the children while over there, because she leaves her children over there alone also. She doesn't care about the father being around her children.
And what firsthand knowledge do you have of that?
They have told me,
Who's they?
Brandon and Becca, they all have admitted that they've left the kids with his parents alone, even her children. So I'm not okay with someone that can leave their own children watching around them, because they don't do it. It's already been proven that both him and her have left the kids there alone.
Okay.
That's why I've asked for it, just to be simply him. If he's tired, simply don't go. It's a responsibility to watch your children around someone that is in that situation. You should want your kids safe more than being around your parents. Or I ask that we just make it where his mother and father cannot be around my kids to keep them safe.
Do you have a third party that can be there?
Do I?
Yeah.
No, because all his siblings, as much as I adore his siblings, they all leave their children alone with their parents also. So I can't highly trust any of them either.
Mr. Myers?
We have never stated that we leave Becca's kids alone with my parents at all. We don't. One of us is always in the house or in the room at all times. Yes, the kids go to other rooms and play with the other kids that are there, because as of right now, my little brother and his wife and their kids live with my parents. And a lot of times, and then I got a little sister that lives there. So there's always somebody else in the house. So we've never left the kids alone, even Becca's kids alone with my dad at all. No one is left alone with my kids. Yeah, my siblings may do it, but I do not. I agree that somebody should be around, whether it's me, Becca, one of my siblings, but I've never fully left the kids completely alone with my father.
Well, clearly we don't have an agreement on this app. Because the parties have to mutually agree on it. I'm not going to sit here and say, this athlete would not be a good person or would be a good person. That's, I don't have any information. All I have is what presented to this court this morning. However, there's only one way to resolve this, absent having a third party there. And I'm just going to go to the draconian measure here. Children are off limits to grandfather, period. While father has care and custody of the children, they are not to be within 100 feet of the individual, residence, place of employment, so further order. Sorry to do it that way, but that's the only other way. Mr. Holden, you prepared the order.
Yes, I will, Your Honor. And as far as the,
Oh, the sanction?
You're right.
That's the sanction. That's the court has ordered. The sanction is going to be parent, the father's off limits.
so this is my comment.
I find him in contempt. I find him in contempt. However, the resolution here, the disposition is grandfather's off limits to children. That'd be the residence within 100 feet of him, nothing. No indirect contact, nothing. So further order. Finally, on the flip side of this, and this is not a court order, but mom, let them be kids and not use them as information.
I typically just ask them how their weekend went, just to make conversation, and then they just start talking.
I'm
That's quite literally, as my mom has witnessed herself.
I'm not going to go into it. I had my meeting with the children and that's how I'm going to leave. So that's how we move forward. We should both the best. Children. Off the record. This is a notice of hearing for request of a personal protection order. You are Carly Prill?
Yeah.
And you are Stephanie Sue Prill?
Yes.
All right, first things first. As the judge with the same last name, the question is, can the court preside over a hearing such as this? I am stating for the record that I do not associate with, and that's not because we decided to do that, but we really don't know each other. I don't associate with Carly Brooke Prill. I never associated with Stephanie Sue Prill. We've never had any conversations. We've never had any family gatherings. We've never done anything where I have been a part of at least that Prill family and my Prill family. Is there any objection to the court proceeding under that basis? Ms. Carly Prill first. Any problem with that? You're shaking your head. Is that a no?
I do not have any problems with that.
Okay. And Stephanie Sue Prill?
No.
Okay. Did I place it under that? Could you both please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
There was a personal protection order request that has been filed by Carly Prill back on February 28th. Court reviewed it. It was an ex parte request, which means she was requesting it on her own without notifying the respondent, and the court denied it and issued an order as a result. On March 15th, a hearing was scheduled requesting that the PPO be authorized. Neither party showed, and the court dismissed the action. For whatever reason, despite no new petition being filed in this case, it's back before the court. Has something changed?
So I had gotten a call from the clerk's office, and, okay, so actually I should start. So the day before, I had gotten a call from the clerk's office. I had went to have the papers served to her, because when I was reading the words on the paper, it said that it had to be served at least a day beforehand. So I went to them 3 days beforehand, and they took it, and then I got a call from the clerk the next day saying that it had to be at least a week and to come in and schedule a new hearing.
I see. Okay. And that explains, I'm not sure why they noticed it that day. All right, we will proceed. The burden of going forward in this is the petitioner. So Ms. Prill, explain to the court why you need a personal protection order.
Well, I don't really feel safe with my mother, Stephanie, having the ability to contact me because of everything that's happened in the past. And I do have a police report and screenshots of our text messages if you'd like to see those. But I just don't really feel safe, especially so we do not live together. I moved out in, I believe it was April of 2023. And since then, I feel like I've been better off without having much contact with her, but I don't really know how better to explain it other than just the emotional aspect of having to stay in contact with her. And then recently, I had pneumonia for a week, and so I didn't go to school for that week because I had a hard time breathing. And my mother did show concern about me not going to school, and I explained to her it was because I was sick. And she kind of dismissed that I was too sick to go to school, and she ended up showing up at the house and demanding that I go with her, or else she will call juvenile hall and have me taken away. So that's what the police report is about, because I had.
You are 18, correct?
Correct.
And you are still a senior in school?
Correct.
So other than that, your allegation of miscontact regarding going to school, what are the other reasons you're requesting a personal protection?
Just every conversation we have is sort of her trying to get me to change how I act because she believes that I'm not responsible and that my priorities aren't in order. Even though I feel like I've displayed responsibility in multiple areas of my life, and it's just sort of turning into this thing where every time I make a decision, she has something to say about it. And it's just getting to the point where I can't deal with that anymore.
Right, has there been any allegations of assault or injury, anything like that?
No.
You are employed as well?
Correct.
Anything else before I go to the response?
I guess just to bring up again that I do have screenshots of all the things she said to me, if you would like to see them. So
Give me a few examples of what she said to you and when.
On March 18th of 2023, she said, "You're a brat, don't talk to me anymore." And I said, "I know I am. I didn't plan on it," as in referring to, I didn't plan on talking to her anymore. And she said, "I wish I didn't have you." And I said, "You've made that clear since I've been born." She said, "Good."
So this is from last year?
Correct. It
Anything,
stems back quite a few years.
okay, anything most recent?
The most recent thing would be February 28th. That's the day that she showed up at the house, just after I called into school and told me that I had to go with her, otherwise she was gonna call the police and have me taken away.
Thank you.
Mhm.
Your response, please.
That is true, but the reason I did do it is because Carly left home because I tried, and she's living with my mother-in-law and her two sons, and they are very dysfunctional in their living. And I tried to make her aware of everybody and their living situations because she lived with her father and I for the last 17 years and has never experienced, she's young and naive in her thinking with relationships of other people. So at the time she was 17, when she left, she started missing school, and it didn't just start in December. The first month she went to school, she missed 3 or 4 days because of a field trip. She didn't take her homework with her, and I had let her know, you're doing extracurricular activities. School comes first, then your activities, then your job. Well, she kept getting everything mixed up, and I let it pass, and then she missed another day, and my girlfriend seen her in town, and I said, "Carly, why are you not at school? I called you in sick." "Well, that doesn't mean I'm not sick enough to do something else." So this went on a couple months, and then I said, "That's it. She's a good student. She's graduating salutatorian of her class, but she has her priorities mixed up because of where she lives and the people that tell her all things all the time, not all the time, but to let her know things about her father and I that aren't true. And so she's listening to all this stuff and never asking me anything. She just assumes everything. And I had tried to about a year ago, and I was under enormous emotional stress for almost till August.
Are you receiving support for it now?
Yes.
Okay.
I was misdiagnosed and I was being treated for bipolarism.
Don't need to explain.
And that was on psychotic drugs for almost 10 years. And when I tried to commit suicide, I got off the drugs, but as a result, I had developed tremors from the lithium. And so they gave me another medication and I got side effects from that.
Ms. Prill, I've heard enough regarding that.
So that was for my
Ms. Prill,
state of mind.
Gotcha.
Your
Final.
Honor, so what she was saying about the people at the house that are influencing me, she's assuming a lot of that, because I don't really talk to most of the people that are there. I mean, we live together, but we don't socialize. We never really talk about my mom or my dad. Like, we pretty much stay apart for the most part. Like, we don't really talk at all. So I don't know where she would be thinking that they're influencing me.
So are you going to be the salutatorian?
That is correct.
Wow, that's wonderful.
Thank you.
Well, this is a PPO request. It's a domestic personal protection order request based upon obviously the relationship between petitioner and respondent. The burden of persuasion rests upon the petitioner to establish why a personal protection order should be entered in this case. Based upon the evidence presented, the court does not find any reason for a personal protection order to be entered in this matter. And as a result, the request is respectfully denied. Wish you both the best. You're both pretty good. Thank you. This is a motion to terminate a personal protection order. Petitioner is present in the courtroom. She's in pro se. The respondent is in the courtroom as well. The respondent's guardian and conservator is also in the courtroom. Would you state your name for the record too, please?
Doreen Essemacher.
And Essemacher?
Correct.
Doreen?
Correct.
All right. On or about March 6, 2024, the court received a request ex parte for personal protection from the petitioner. The court reviewed the petition and on the same date had authorized the personal protection order against the respondent effective that date to continue to August 6, 2024. Subsequent to that, the respondent had filed a motion to terminate the personal protection order dated March 11th. So the hearing this morning is to determine whether the personal protection order is to continue. The burden of proof or burden of persuasion rests upon the petitioner as to why the personal protection order should be granted. So Ms. Butch, why do you believe this personal protection order should continue?
A few years ago, the Essemakers and Ledger moved in next door to where I live. Shortly after that, Nathan has pretty much in a consistent manner come into the library. Used to be at my residence, but would always come into the library and wanted attention, asked why I would not talk to him the same way I talk to other people, made inappropriate, not suggestions, but just remarks.
Can you give me an example?
I'm sorry?
Could you give me an example, please?
At one time, he asked me if I was wearing a bra. And so this went on. At first, I was polite because they are our neighbors. I was polite, and then he came to me and said that he had feelings for my daughter, who he had no contact with besides her coming over and saying hello to him a couple of times as she was coming in the house. So at that point, I knew I had to break off everything with him because he just, so I told him to leave me alone, leave my family alone, stay off my property. But he still could, of course, can continue to come into the library, which he did. This went on for over a year, where he would just try to engage in conversation with me, but I was not, responding, or very shortly. I would not give him any response. And then the last time, so then he's been going to people that I work with to ask them to talk to me and that I should not be mean to him. It's embarrassing. It's beyond, it's just ridiculous. And it's got to the point where he needs to stop. This has just gone on way too far. I've done everything. I've been nice. I've been rude. I've been downright mean, trying to get him to stop, to leave me alone. And I can't get him to stop. I can't get him to figure this out.
Thank you. We have the response.
Yes.
Your Honor, I promised, I never asked Ms. Butch if she was wearing a bra. I did tell her that her daughter was great. I never stated that I had feelings for her. Yes, we're neighbors and everything, but I've just been nothing but a friendly person to Ms. Butch, and I'm just confused about why she had a protection order. Yes, I've been to the library, but everybody has the right to go to the library. I have been going to the council meetings because it's a public place. Ms. Butch didn't like the fact that I was recording the meetings because I would put them on YouTube. She didn't like being recorded. So that's where we had another problem. I don't feel like I'm harassing Ms. Butch. If she feels that way, that's awfully kind of her. But if she doesn't want to talk to me, then I can respect that. So it's unfortunate. But I just don't want a protection order. Because that wouldn't be fair. Let's say, for example, if I'm at Walmart and Ms. Butch is at Walmart, then I would have to leave. That wouldn't be fair to me. So, and I have my guardian here with me that I can tell you more. But I'm just saying, I don't feel like this protection order is necessary. I would not talk to Ms. Butch if she wishes for me not to. If she doesn't want any contact with me, so be it. Okay, I'll respect that. But
she has stated in her statement that she tried to contact me numerous times to talk about Nathan. She has not. She's messaged me through Facebook twice. We've been there since 2018, and she has never told me. This is the first time I'm hearing about the bra incident. Had she told me all this, I would have told him, stay away from the library, don't even go to the town meetings. Because I know he likes to go out in the community, and he likes to observe things, and he doesn't have anything else due to his history. He just wants to be part of the community. He might be going in the wrong way, but I told him that he is not to go to the library anymore. He is not to engage with Miss Butch. Our driveways are 5 feet apart. That's how close we are.
Oh, I know.
So he knows, and he does not want, we do not want this protection order on him.
Very well. You get the final say, as you are the petitioner. Go ahead.
I know Nathan has problems, and I tried to respect that. which is why it's taken me so long to bring this about, because I thought we could work it out on our own. I don't want there to be bad feelings, since, we are within a few feet of each other. And if I see them out, you're raised to be polite. So, you can wave to people as you see them in the streets. That does not mean I want to be his friend. And I can't seem to get that across to him that, but it concerns me that he doesn't understand why I don't talk to him like I talk to other people. There's just a lot of red flags that have been coming up. And the last one, when he was in the library, and I told him to leave me alone, that, he just needed to just stop. He said, I didn't have to be a bitch about it. And it's like, everything seems to be escalating a little bit. And that's when I decided it was time to put this in order, because I'm afraid it's going to go a little bit further.
Thank you. The court has had the opportunity to hear everyone speak regarding this. The court has also had the opportunity to review the petition and the responding documentation as well. And the court does not grant personal protection orders willy-nilly. As a matter of fact, recently, with recent case law, there has been specific reasons why denials are made, as well as reasons why personal protection orders are granted. And we've seen a flurry of a number of these requests come through, domestic or non-domestic. And it's just a new day. It's a new day because we have different laws, different perspectives, and obviously the ultimate goal here is harmony in the community where we don't have issues like this. Just speaking personally, the respondent in this case is a frequent individual that visits the court. No issues, no problems. He's entitled to be here. He's welcome to be here. There's never been a problem with that. Courts never had seen anything that would be indicative of a little concern here. However, when I read the petition and I look back in time based upon the allegations and heard what I heard today, despite the denial of this case, there's truly a valid reason why this personal protection order should be continued. Court finds that there has been repeated contact. The repeated contact has been no more than harassing at best. It could be annoying, but under the statute, harassing. And hearing the statements, I'm continuing the personal protection order in this case. It's effective until August. And I'm hoping during that time frame, things can calm down. Parties can continue on with their lives. And notice when I entered the order originally, when I put in appearing within sight of, the court had scratched that out. And the reason for that is because you're neighbors. I couldn't imagine a situation like that, but certainly following. And so there's a valid reason for the personal protection order, and it shall continue over a judge. This is an appeal from the district court proceeding. The appellee, Michigan Dream Builders, Michigan Dream Builders LLC, the appellee represented by Attorney Scott Mancinelli, and Ms. Rebecca May Caldwell appears in the courtroom in pro se. Court has, Ms. Caldwell filed an appeal in this case, but court sees there's no lower court transcript. There's nothing for the court to review in this matter. Ms. Caldwell, do you have any response to that?
I was contacting a few lawyers, and I found one that I'm waiting to get back with. Is the Attorney Tate lawyer group. They have a class action lawsuit with Ross Medical School. There's a lot of other people that have attended the school with the same complaints as mine.
Well, don't want to go on the merits here, but my question is, I don't have a transcript of the hearing, the summary disposition motion hearing that you're appealing. I have no idea what you're, I can read in your pleadings what you're trying to appeal, but I don't see any transcript of the hearing.
A transcript of the hearing.
Yeah, I don't have one. Think about that for a second. Mr. Mancinelli, do you have any comment regarding this, sir?
Well, we have no transcript, there's no record, and she didn't file a response to the motion for summary disposition that she's appealing. So whatever issues that she has with the judgment were not preserved, they weren't argued in the lower court. So there's nothing to appeal on. She didn't preserve any arguments. They're all waived by not arguing them in the first place, and there's no transcript. You know, I'm sorry she doesn't know what she's doing, but you know, this has been pending since September. I was surprised that we even set a hearing for it, frankly. So that's why I kind of got this appellate brief done at the last minute. Because I didn't think it was even going to go forward. I think it has to be denied.
Did you receive the statement that I sent in?
I have received, other than the appellee's brief on appeal, there's an enclosed statement dated March 9, 2024.
Yes.
Okay, I have that.
Okay.
I also have nearly a full page letter entitled LLC Michigan Dream Builders versus Rebecca Caldwell. This is I, Rebecca Caldwell, am a disabled person. So I've received that. Court has also received from the district court, the lower court, that the transcript is available. It's on file with the court, but it's not been, wait a minute. Record can be transmitted to the circuit court includes. So did you pay for a transcript or seek a transcript?
No.
No. Okay.
I'm sorry.
No, you don't need to be sorry. All right. Well, based upon that, the court does not have a record to review the appeal that has been sought in this matter by the appellant, Ms. Caldwell. There's no transcript. The court did read the file. Because this plea is not, or this appeal has not been properly perfected along the lines of receiving a transcript, the appeal is respectfully dismissed.
So I have a question, Your Honor. I received a letter in the mail from, here it is. It's from them, and I don't quite understand. They're trying to garnish wages, but I'm on Social Security disability.
Okay, I can't answer any legal questions regarding any garnishment.
I don't think that it's lawful.
Well, you may have to file a paperwork to address that, but that's not before the court today, Ms. Caldwell. I mean, no disrespect, but I have no transcripts to review. As I stated, the appeal is dismissed in this case.
It's kind of like trying to collect money from a turnip at this point.
Well, I can't address that either. There's a district court order, and in fact, the lower court will, may have to address it there, but the appeal is denied in this case. That'll be all. Thank you.
Thank you, Your Honor. Thank you, Your Honor.
Off the record.
So what does that mean?